On a quiet morning in Marion County, Indiana, an 83-year-old grandmother slowly walked into the courtroom. Her name was Eleanor Whitaker. She looked fragile, small, confused. She wore a pale cardigan over a floral blouse, and she moved with the careful, deliberate pace of someone who needed the world to slow down and wait for her. Her white hair was pinned neatly. Her hands, when she was seated, found her lap and settled there, with a tissue tucked between her fingers. Throughout the trial, she spoke softly, sometimes pausing as if struggling to remember what had happened that night, looking at the ceiling with the expression of someone reaching for a word that keeps moving just out of reach. According to Eleanor, the tragedy was nothing more than a terrible accident. She had prepared dinner. Her grandson had eaten, and later that night, he became violently ill. By the time help arrived, it was too late. The defense argued the elderly woman had done nothing wrong. Perhaps spoiled food, perhaps a cooking mistake. Just an old woman who did not realize something had gone bad. But investigators had sent samples from the victim's blood to a forensic laboratory, and the results had arrived in court. Because hidden in those results was a single discovery that would change everything. A toxicology report. One document that would reveal exactly what the victim had swallowed that night. And by the time Judge Nathaniel Crowe spoke Eleanor Whitaker's name for the final time, the story of a tragic accident would be gone forever. The victim's name was Daniel Whitaker. He was 41 years old, the only child of Eleanor Whitaker's late son, and he had been living in the house his father had left him, a 3-bedroom property in the Meridian-Kessler neighborhood of Indianapolis, that had been in the family since the 1970s. Daniel worked in information technology for a healthcare company. He had a quiet social life, a small group of close friends, and a fondness for cooking that he had developed during the pandemic years and never abandoned. His colleagues described him as reliable and methodical. His friends said he was the person you called when you needed someone to think through a problem carefully and without drama. He was not a person who made enemies. He was not a person who imagined that enemies were necessary to his life. He had inherited the house when his father died 2 years earlier. He had also inherited, through his father's estate, a sum of money from the sale of a commercial property in Carmel that had been held in trust until the settlement of the estate. The total value of the inherited assets was approximately $700,000. Under the terms of the estate, if Daniel died without a spouse or direct descendants, the remaining assets would transfer to his surviving family members, the first among whom was his grandmother, Eleanor. Detective Samuel Ortega was assigned to the case by the Marion County Sheriff's Office on the morning after Daniel Whitaker was pronounced dead at Methodist Hospital. The initial call had come in as a possible poisoning from the hospital's emergency department, where Daniel had been brought by ambulance after his neighbor found him collapsed on the porch of his house at 10 in the evening. The attending physician had ordered comprehensive blood work immediately. The results were not what anyone expected from a suspected case of food poisoning. The attending physician had called the police before he called the family. Ortega drove to the house on Guilford Avenue and stood in the kitchen with the investigative team and looked at the space methodically, the way he always did when he arrived at a scene, taking inventory without touching anything, building a mental map. The kitchen was clean and orderly. Unnaturally clean, he thought, for a house where someone had recently become so ill they had collapsed on the porch. Sick people did not tidy up. They lay down. They called for help. The clean kitchen was the first thing he wrote in his casebook, even before the cabinet. A pot was on the stove with the burner off. Dishes had been done, There was a glass on the counter near the sink, rinsed. The space gave nothing away immediately, which was itself something. He asked the team to check every cabinet and every storage space. The house had a utility closet off the kitchen, one of those narrow spaces with a bifold door, stocked with cleaning supplies and tools, and the accumulated miscellany of a house that had been occupied for decades. On the lower shelf, behind a can of wood finish and a box of light bulbs, was a plastic bottle with a faded label. The label read, Gramoxone. The bottle was approximately 3/4 full. One of the evidence technicians photographed the bottle in place before bagging it. Ortega photographed it too, on his phone, for his own reference. He knew the name Gramoxone. He had grown up in a farming community outside Lafayette and had heard the name enough times to know what it was. Paraquat dichloride, one of the most toxic agricultural pesticides in common use. Banned for home use in the United States since the 1980s, but still present in older storage, still findable in the back corners of properties that had not been fully turned over. The bottle had not been purchased at a garden center recently. The label was decades old, but the bottle was not empty. He bagged it himself and signed the chain of custody form. Then he called the hospital to confirm that the blood work results were being preserved and to request that the samples be sent to the State Forensic Toxicology Laboratory for comprehensive compound analysis. The hospital's attending physician said he had already made that request. Ortega drove to Eleanor Whitaker's house in Broad Ripple that afternoon. It was a small house, well kept, with window boxes and the bird bath in the front yard. Eleanor answered the door herself. She was wearing a house dress and slippers and had clearly been crying. She invited him in without hesitation, which he noted. She offered him coffee, which he declined. She sat in a rocking chair in the living room, with her hands folded in her lap, and looked at him with an expression of genuine, complete devastation. She told him about the dinner. She had called Daniel on a Thursday afternoon and invited him for Sunday dinner, something she did every few weeks. He had come at 5 in the evening. She had made pot roast and green beans and rolls from a tube, because she was honest with herself about the limits of her baking. They had eaten together. Daniel had seemed fine. He had stayed until about 8, watched some television with her, and then gone home. She had not heard from him again. She had found out what happened from a call the next morning. Ortega asked her about the utility closet in Daniel's kitchen. She looked briefly blank and then said she did not know what he was asking. He described the bottle. She said she had no idea what that was. He said the name of the compound. She shook her head and said she did not know anything about chemicals. He thanked her and left. He sat in his car in front of her house for a few minutes. He thought about what she had told him and what she had not told him, and the specific quality of the brief blankness that had crossed her face when he described the bottle. He had been doing this long enough to have a catalogue of expressions. The blankness had been too brief to be genuine confusion. It had been the half-second of a person who knows the thing they are being asked about and is deciding how to respond to being asked about it. He drove back to the station and began the financial research. He requested Daniel Whitaker's probate file from the county courthouse and spent an afternoon reading through it. He requested Eleanor Whitaker's financial records through a subpoena filed that same afternoon. He called the legal services office she had contacted earlier in the year and confirmed the 2 calls had been made from her number on her landline. He called the estate attorney Lawrence Webb's office and confirmed the 2 calls there as well. He pulled the property tax records for the Broad Ripple house and found the delinquency. He pulled Eleanor's medical billing records under the authority of the investigation warrant and found the overdue equipment charges. He built the financial picture piece by piece, the way he always built pictures, until he could see its full shape. The financial picture that emerged over the following week was detailed and specific. Eleanor Whitaker had been living on a fixed income, a social security payment, and a small pension from her late husband's railroad employment for 7 years. In the past 3 years, her expenses had outpaced her income in a way that had been managed through the progressive depletion of a savings account that was now nearly empty. She had 2 overdue notices from a medical equipment provider for a home oxygen concentrator she had needed after a respiratory illness the previous winter. She had a property tax delinquency notice on the Broad Ripple house, which she owned outright for the previous year's assessment. She had made 2 calls to a legal services office earlier in the year about estate planning questions. The legal services office had no record of her actual appointment. She had not followed through. Daniel's estate was valued at approximately $680,000 at the time of his death, after estate taxes and fees from his father's estate had been settled. If Daniel died intestate and without direct descendants, his grandmother was the next of kin. Ortega sat with the assembled file for an hour before calling Ellison. He had done this kind of financial research before, in other cases, with other motives, and he was familiar with the specific unpleasantness of watching a picture become clear when the picture was this kind. He thought about Eleanor Whitaker in the rocking chair with her folded hands and her genuine-looking devastation. He thought about the half-second blankness when he had mentioned the pesticide bottle. He thought about the firmness of her grip on the officer's arm when she had been escorted to the patrol car. He called Ellison and described what he had found. She listened without interrupting. When he finished, she asked one question. "Is there anything in the financial picture that Daniel would have known about?" Ortega said yes. He said Daniel had been copied on the property tax delinquency notice because the property had passed through his father's estate documents and his address had remained on the county notification list. He said Daniel had known his grandmother was in financial difficulty. "He would have been sympathetic," Ellison said. "Probably," Ortega said. She told him to get her the toxicology report when it arrived. The toxicology report came back 18 days later from the State Forensic Laboratory in Indianapolis. The laboratory had performed a comprehensive mass spectrometry analysis of Daniel Whitaker's blood samples and had identified, among other compounds, a significant concentration of paraquat dichloride. The concentration was quantified at a level that the laboratory's report described as consistent with lethal acute ingestion. The report noted that paraquat was a restricted-use pesticide in the United States, was not present in any food product or consumer substance, and required direct ingestion to achieve the concentration found in the blood samples. The report further noted that paraquat poisoning of the severity found in the blood samples would typically produce symptoms within several hours of ingestion, including gastric distress, organ damage, and progressive respiratory failure, a sequence that was entirely consistent with the clinical picture described in Daniel Whitaker's hospital records. The report was 42 pages long. Its conclusion fit in a single sentence. The forensic laboratory then received the bottle recovered from Daniel's kitchen, bagged and logged under the evidence chain number from the scene collection. Laboratory analysis of the bottle's contents confirmed it contained paraquat dichloride. A comparison of the chemical signature of the compound in the bottle with the compound identified in Daniel's blood samples produced a match that the laboratory described in its report as chemically identical. Ellison read the toxicology report 3 times. Then she filed the first-degree murder charge. Eleanor Whitaker was arrested at her home in Broad Ripple on a Tuesday morning, 6 weeks after Daniel's death. She came to the door in her house dress again, and when she saw the detective and the uniformed officers, she pressed her hand to her chest in an expression of shock that was entirely controlled and arrived exactly 1 second too late. She said, softly, that she did not understand. She said she was an old woman and she had done nothing wrong. One of the uniformed officers assisted her to the patrol car, and she moved slowly and carefully, each step deliberate, her hand gripping the officer's arm with a firmness that the officer later described in his notes as surprisingly strong for someone her age. Her attorney, appointed by the court because her financial position had deteriorated to the point where she could not retain private counsel, was a public defender named Roger Olcott, who had been practicing in Marion County for 9 years and who approached every case with the same disciplined, professional commitment, regardless of his personal views about the evidence. He reviewed the case file in its entirety before his first consultation with Eleanor. He reviewed it thoroughly and without shortcuts. He was a careful man. He visited Eleanor at the county jail 3 days after her arrest. She was seated at the consultation table when he arrived, wearing the jail's standard-issue clothing, and she had arranged her expression carefully before he came in. She looked at him with the eyes of a grandmother, which was not something she could help, but which she had clearly decided to deploy. She spoke slowly and with pauses that were slightly longer than necessary, the rhythm of a person managing the impression of cognitive difficulty. "Mrs. Whitaker," Olcott said after the introductions, "I need to go over the evidence with you, and I need you to help me understand it. Not the story you want me to understand, the actual facts." He placed the toxicology report on the table between them. "This report says Daniel died from paraquat poisoning. Paraquat is an agricultural pesticide. The same compound was found in a bottle in Daniel's kitchen. The laboratory says they are chemically identical." Eleanor looked at the report. She looked at it with the expression of someone looking at something written in a language they cannot read. "I don't know anything about that," she said. "The bottle was found in Daniel's kitchen," Olcott said carefully. "Not in your home. In his kitchen. Do you know how a bottle of paraquat pesticide would have come to be stored in Daniel's kitchen?" "I have no idea," Eleanor said. Olcott set his pen down on the table. He looked at her. "Mrs. Whitaker, the prosecution is going to argue that you brought that bottle to Daniel's house. They are going to argue that you introduced the pesticide into Daniel's food during the dinner you prepared for him on Sunday evening. They are going to present financial evidence showing your debt situation and your position as the next beneficiary of Daniel's estate." He paused. "I need you to tell me whether there is anything in that account that is inaccurate." Eleanor looked at her hands. She looked at them for a long moment. Then she looked up. "I am an old woman," she said. "I am 83 years old, and my grandson is gone, and I am in this terrible place, and I did not do what they are saying I did." Her voice was soft and measured, and carried the practiced weight of practiced sorrow. "I made Daniel dinner. He ate. Something went wrong, and I do not know what it was. I have been asking myself every day since he died what I might have done differently, and I do not have an answer."
Olcott looked at her steadily. "Mrs. Whitaker, I want to ask you something directly, and I am asking it because I am your attorney, and what you tell me is privileged. Did you know what paraquat was before the detective mentioned it to you?" Eleanor was quiet for a moment that lasted a fraction of a second too long. "No," she said. "The house in Broad Ripple where you live," Olcott said. "Before your husband passed, before Daniel's father passed, was there ever any agricultural or garden chemical storage in that house?" "My husband was not a gardener," Eleanor said. Olcott wrote nothing. He looked at his notepad and then at his client. He had been a public defender for 9 years, and he had represented people who were guilty and people who were not, and some who existed in the complicated space between those categories. Eleanor Whitaker did not exist in a complicated space. The toxicology report was unambiguous. The financial motive was documented. The pesticide was in his file. He was going to defend her as effectively as the evidence allowed, which meant he was going to challenge the forensic methodology and challenge the financial interpretation and challenge the chain of custody wherever he could find a gap. He was going to do his job. He had one more question. "Mrs. Whitaker, the estate attorney, Lawrence Webb."
You called his office twice in the year before Daniel's death to ask about the estate. What specifically were you asking? Eleanor looked at the wall. "I was asking about my husband's things," she said. "Some papers, family items. I wasn't sure where they had ended up in all the estate work."
Olcott wrote this down. He wrote it down because he was her attorney, and it was his job to write down what his client told him. He did not write down what he was thinking, which was that this answer was specifically and carefully constructed to describe a plausible reason for calling an estate attorney that was not the reason she had called. He had read the notes from the second call. She had asked what happened to Daniel's assets if he died without a will and without direct descendants. That was not a question about family papers. He closed his notepad. He was going to build the best case available. He had 9 years of experience doing exactly that, but he was already thinking about how to approach the sentencing phase. The arraignment was held in Marion County Superior Court, and Eleanor Whitaker walked into the courtroom with the same careful, deliberate pace she had used on every occasion where she was being observed. She wore a grey cardigan and pearl earrings and held a tissue in her right hand. She looked around the courtroom with an expression of bewildered sorrow, as though she could not quite understand what she was doing in such a place. When the court asked her to enter her plea, she stood slowly, using the table for support, and said, "Not guilty," in a voice that was barely above a whisper, and that carried in the quiet room with perfect clarity. Olcott had coached her on nothing beyond the bare minimum of courtroom procedure. He had not coached her on her presentation. The presentation was entirely her own, and he recognized that immediately when he watched it. She had arrived at her defense performance independently from a lifetime of understanding how she was perceived and how to use that perception. The tissue, the soft voice, the slight confusion, the air of a woman out of her depth in a world that was too hard and too cruel for someone of her age and frailty. It was, he thought, watching her, a very good performance. He did not tell her this. The performance would not waver until the moment the toxicology report was read aloud, which was weeks away.
The trial began in early spring, when the light coming through the courthouse windows had the new, tentative quality of a season not yet sure of itself. The jury had been selected over 2 days with care on both sides. Ellison had focused her challenges on jurors who expressed strong sympathy for elderly defendants, or who described their own grandparents in terms that suggested they might find the idea of a grandmother's guilt psychologically impossible to accept. Alcott had challenged jurors who indicated familiarity with the science of toxicology, or who described themselves as having personal experience with inheritance disputes. What remained was a panel of 12 people who had agreed to follow the evidence wherever it led, and who would be sitting in their seats when the toxicology report was displayed on the screen at the front of the courtroom. Eleanor sat at the defense table and performed. She performed with dedication and consistency throughout the entire trial. She wore cardigans of varying pastel colors and kept a tissue in her hand. She leaned toward Alcott when he spoke to her and nodded slowly as though absorbing difficult information. When testimony was emotional, she dabbed at her eyes. When testimony was scientific, she looked at the witness with the polite, confused attention of someone who is trying very hard to follow something beyond their comprehension. Several members of the gallery watched her and felt the pull of sympathy that the performance was designed to produce. This was its purpose. Eleanor Whitaker had understood something, sometime in her long life, about the way that fragility functions as armor. She had spent decades operating within a specific social contract in which elderly women were assumed to be gentle and harmless and unthreatening. She had built her presentation on that contract. The tissue and the soft voice and the slow pace were not theatrical inventions. They were refinements of a natural baseline. The careful amplification of qualities she genuinely possessed, deployed now in a specific context for a specific purpose. The best performances are built on real materials. Eleanor Whitaker's performance was built on 83 years of being exactly the person she was presenting herself as being, except for one specific moment on one specific Sunday evening in her grandson's kitchen, when she had been someone else entirely. What she had not understood, or had not adequately accounted for, was the toxicology report. The prosecution's early witnesses built the foundation of the case methodically. Ortega testified about the investigation, the discovery of the pesticide bottle, and the financial research. He described the scene at Daniel's house, the clean kitchen, the rinsed glass, the utility closet, the bottle with its decades-old label. He described the financial profile of Eleanor Whitaker and the inheritance structure of Daniel's estate. He was thorough and factual, and he did not dramatize. Ellison walked him through the financial evidence carefully. Detective Ortega, can you describe Mrs. Whitaker's financial situation at the time of Daniel's death? She had a checking account with a balance of approximately $800, Ortega said. Her savings account, which had held approximately $42,000 2 years earlier, had been drawn down to just under $3,000. She had 2 outstanding medical equipment bills totaling about $2,400. She had a delinquent property tax notice for the current year. Her monthly expenses exceeded her income by approximately $400. And Daniel Whitaker's estate? Approximately $680,000 in total assets, primarily from the inheritance from his father and the appreciated value of the Guilford Avenue property. Ellison asked whether Eleanor was aware of the value of the estate. Ortega said that the estate settlement had been a matter of probate court record, which was publicly accessible, and that Eleanor had been present at several of the estate proceedings following her son's death 2 years earlier. Alcott cross-examined him carefully on the question of the pesticide bottle's provenance. He established that the bottle had been found in Daniel's kitchen, not Eleanor's.
He asked whether investigators had any direct evidence that Eleanor had ever been in Daniel's utility closet. Ortega acknowledged there was no direct evidence of Eleanor accessing the utility closet. Alcott asked whether the bottle might have been in the house for years, perhaps from a previous occupant. Ortega said the house had been in the Whitaker family since the 1970s and had not had non-family occupants. Alcott asked whether Daniel could have purchased the bottle himself at some point. Ortega said investigators had found no receipt, no record of purchase, and no other indication that Daniel had bought pesticide of any kind. Alcott noted for the jury that the absence of evidence linking Eleanor directly to the bottle's placement remained. It was a modest point, but he placed it carefully. A family attorney named Lawrence Webb, who had handled the estate documents for Daniel's father, testified about the inheritance structure and confirmed that Eleanor Whitaker was the next of kin under the terms of the estate. He confirmed that the estate was valued at approximately $680,000.
Ellison asked him whether Eleanor had contacted him at any point in the year before Daniel's death to ask about the estate. Webb said yes. He said she had called his office twice. She had asked, on the second call, what would happen to Daniel's assets if he died without a will and without direct descendants. Alcott cross-examined Webb briefly, asking whether the question Eleanor had posed was unusual. Webb said it was not unusual for family members to ask estate planning questions. Alcott asked whether the question could be interpreted as an expression of concern for Daniel's planning needs, rather than a personal financial calculation. Webb said it could be so interpreted. Alcott thanked him. At the defense table, Eleanor's hands, which had been resting in her lap with the tissue, tightened slightly. The tissue crumpled. A family member named Patricia Greer, who was a cousin of Daniel's and had grown up with the extended Whitaker family, testified about a conversation she had overheard at a family gathering 6 weeks before Daniel's death. She said Eleanor had been talking to Daniel in the kitchen about money. She said the conversation had escalated. She said she had heard Eleanor say that the house and everything in it should have gone to the family, and that Daniel did not appreciate what he had been given. She said Daniel had told Eleanor to stay out of his finances. She said Eleanor's face, when Daniel left the room, was not the face of a grieving or hurt person. It was something colder. "Can you describe what you mean by colder?" Ellison asked. Patricia thought for a moment. "It was the face of someone who has made a decision," she said. "I have thought about it many times since Daniel died. At the time, I thought she was just upset. But looking back, it was not upset. It was resolved, like something had been settled in her mind." Alcott cross-examined Patricia on the details of what she had heard, establishing that she had not heard the full conversation, that she had been in the adjacent room, that family conversations about money were common, and did not necessarily indicate anything beyond ordinary family tension. Patricia agreed with these qualifications, but maintained her description of Eleanor's expression when Daniel left the room. The medical examiner who had performed the autopsy, a physician named Dr. Howard Lentz, testified on the 4th day. He described Daniel Whitaker's internal injuries in clinical terms that required the jury's close attention, and that Ellison walked through with patience and precision. The organ damage was extensive and systematic. The lungs, the kidneys, the liver had all shown the effects of a toxic agent. The pattern of damage was, Dr. Lentz testified, consistent with acute paraquat ingestion. It was not consistent with food poisoning.
Food poisoning produced a specific and recognizable pattern of gastrointestinal disruption. What Daniel Whitaker's body showed was something categorically different. The systemic shutdown that occurs when a highly toxic chemical compound enters the bloodstream in sufficient quantity. Dr. Lentz, Ellison said, in your professional opinion, is it possible that the organ damage you documented could have been caused by spoiled or contaminated food? No, Dr. Lentz said. The pattern of damage I documented is not consistent with food-borne illness of any variety. The specific distribution of organ damage, particularly the pulmonary fibrosis pattern in the lungs and the tubular necrosis pattern in the kidneys, is characteristic of paraquat toxicity. I have seen this pattern twice before in my career, both in confirmed paraquat ingestion cases. Alcott challenged Dr. Lentz on the certainty of his differential diagnosis, asking whether the same organ damage profile could be produced by other toxic compounds. Dr. Lentz acknowledged that other compounds could produce similar effects. He maintained that the pattern in this case,
taken together with the toxicology report that he had reviewed, was consistent, specifically and conclusively, with paraquat ingestion. Alcott asked whether he had based his autopsy assessment on the toxicology results, or whether the autopsy assessment was independent. Dr. Lentz said the assessments were consistent with each other, and that each supported the other. He said the two lines of evidence had been developed independently, and that their convergence strengthened rather than compromised the conclusion. A toxicologist named Dr. Renata Vasquez, who had been with the State Forensic Laboratory for 12 years, took the stand on the 5th day. She was the witness Ellison had been building toward, and she handled her testimony with the care of someone who understands that the difference between a verdict and an acquittal can come down to whether a jury understands a scientific finding or simply takes it on faith. She did not want them to take it on faith. She wanted them to understand it. She began by explaining the laboratory's analytical process. Mass spectrometry, she told the jury, was a technique for identifying the molecular composition of a substance by measuring the mass of its component ions. It was the most precise analytical tool available for chemical identification. The technique produced a molecular fingerprint that was unique to each compound and could not be mimicked or replicated by accident. She explained the process in terms that were accessible without being condescending, using analogies that the jury could follow, comparing the molecular fingerprint to the kind of specific, unique identifier that could not be confused with any other. She paused after each explanation to ask whether the jury had questions through the judge. The jury was paying close attention. Dr. Vasquez, Ellison said, before we discuss your specific findings, can you tell the jury what paraquat is and why it is significant in this case? Paraquat, or paraquat dichloride, is an agricultural herbicide that was widely used in the United States from the 1960s through the 1980s, Dr. Vasquez said. It was banned for non-agricultural use in the United States in 1989 because of its extreme toxicity. It remains one of the most acutely toxic substances commonly found in older properties. As little as 1 teaspoon of a concentrated paraquat solution can be lethal to an adult. There is no antidote. Once ingested in sufficient quantity, the compound causes progressive oxidative damage to the lungs, kidneys, and liver that cannot be reversed. The time from ingestion to death varies depending on the dose, typically between 1 and 30 days for doses above the acute lethal threshold. What is the acute lethal threshold?
The established acute lethal threshold for paraquat ingestion in adults is approximately 0.12 milligrams per liter of blood. Below this level, medical intervention may be effective. At or above this level, the prognosis is very poor, regardless of treatment. Ellison asked her to describe the analysis of Daniel Whitaker's blood samples. The laboratory had received the samples under chain of custody documentation and had processed them using standard forensic protocols. The mass spectrometry analysis had identified paraquat dichloride. The concentration was specific and measurable. She read the number from her report. "And how does that number compare to the lethal threshold?" Ellison asked. "The concentration found in Daniel Whitaker's blood is 0.42 milligrams per liter," Dr. Vasquez said. "That is 3.5 times the acute lethal threshold." The courtroom was quiet. Several jurors had been writing notes and had stopped. Dr. Vasquez then described the analysis of the bottle recovered from Daniel's kitchen. The laboratory had received the bottle under chain of custody documentation and had extracted a sample of the liquid contents for analysis. Mass spectrometry analysis of the bottle's contents had produced a molecular fingerprint. She compared that fingerprint to the fingerprint of the compound identified in Daniel's blood. Ellison asked her to describe the result of that comparison. Dr. Vasquez looked at the jury and said clearly that the two samples were chemically identical. Not similar, not consistent, identical. The compound in Daniel Whitaker's blood was the same compound that had been stored in the bottle in his kitchen. Ellison asked whether the compound could have entered Daniel Whitaker's body through any route other than deliberate ingestion. Dr. Vasquez said no. Paraquat was not airborne at normal temperatures and pressures. It was not absorbed through skin contact in the concentrations present in diluted pesticide formulations. It was not present in any food product or cooking ingredient or household substance. To achieve the concentration found in Daniel Whitaker's blood, the compound had to have been ingested. It had to have been consumed in food or liquid. Ellison asked whether Daniel could have accidentally ingested the compound from the bottle. Dr. Vasquez said the bottle had been stored in a utility closet, not in the kitchen's food storage areas. Accidental ingestion of a pesticide stored in a utility closet would require a specific and unusual sequence of events. She said she could not rule out a theoretical accident, but she said that the concentration found in the blood, the location of the bottle, and the circumstances of the case taken together were not consistent with accidental ingestion. A person does not accidentally consume 3.5 times the lethal dose of a pesticide stored in a utility closet, she said. Accidental ingestion would typically involve a small quantity of the substance. The concentration in these samples does not suggest a small or incidental exposure. Ellison sat down. Alcott's cross-examination was his most extended effort of the trial. He challenged the chain of custody documentation, asking Dr. Vasquez to walk through each handoff of the blood samples from the hospital to the laboratory. She did so without difficulty. He asked whether the laboratory's equipment had been calibrated and certified on the date of the analysis. She confirmed it had and produced the certification records. He asked whether mass spectrometry analysis could produce a false positive identification under any circumstances. She acknowledged that false positives were theoretically possible in cases of sample contamination or equipment malfunction, but that both the calibration records and the internal laboratory controls used during this analysis had detected no such issues. He asked whether the phrase chemically identical allowed for any margin of measurement error. She said that the comparison had a confidence interval of greater than 99.9%, and that within the precision of mass spectrometry analysis, the samples were identical. He asked whether it was possible that both samples, the blood and the bottle's contents, could have been contaminated by the same environmental source during collection or handling. Dr. Vasquez said that the chain of custody documentation showed the two samples had never been stored together, had been collected by different evidence technicians, and had been processed in separate analytical runs at the laboratory. Cross-contamination between the samples was not possible under those conditions. Olcott sat down. The prosecution then asked the technician to display the toxicology report on the courtroom screen. The report filled the display, its laboratory letterhead at the top, its findings laid out in the specific, formal language of forensic science. Ellison asked the technician to highlight the key finding section. The highlighted text read as follows: "The blood samples from decedent Daniel Whitaker contain paraquat dichloride at a concentration of 0.42 milligrams per litre,
exceeding the established acute lethal threshold of 0.12 milligrams per litre. Analysis of the liquid substance recovered from the evidence bottle under custody number MC-2024-0078 identifies the same compound at a purity of approximately 24%, consistent with diluted paraquat formulations. Molecular comparison of the paraquat signature from both samples confirms chemical identity. Cause of death consistent with acute paraquat ingestion." Ellison turned to face the jury and read those last 6 words again, slowly. Cause of death consistent with acute paraquat ingestion. Then she turned and looked at Eleanor Whitaker. Eleanor's hands had separated from each other in her lap. Her right hand had found the armrest of her chair and was gripping it. The tissue was on the floor. Her face, which had maintained its careful expression of confused sorrow throughout 5 days of testimony, had changed. The architecture of the performance had been built on the assumption that the evidence would remain at a level of abstraction, that the chemical science would be confusing enough and distant enough from ordinary human understanding that the jury would not fully feel its weight. The highlighted words on the screen were not abstract. Cause of death consistent with acute paraquat ingestion. 6 words, not jargon, not probability language, a clear statement. Eleanor looked at the screen. Then she looked down at the armrest she was gripping. Her hands were trembling. Not the performance of trembling that she had deployed in earlier moments of the trial, the careful, slight shake that communicated fragility. This was actual trembling, the movement of a body that has lost its organizing principle and cannot quite hold itself still. In the gallery, Daniel's friends sat together in a group of 4. They had come every day. One of them put his hand over his mouth. Another looked at the ceiling for a moment and then back at the screen. They did not speak. They had spoken at length in the months between Daniel's death and this trial, in the specific, repetitive conversations that people have when something has happened that they cannot absorb. And they had run out of words some time ago. They were here for something that was not words. Patricia Greer was seated 2 rows behind them. She was looking at Eleanor Whitaker's hands on the armrest and at the tissue on the floor, and at the changed expression on her cousin's grandmother's face. And she was understanding something that she had suspected, but had not let herself fully believe. Olcott made his closing argument with professional care. He challenged the certainty of the forensic chain. He argued the absence of direct evidence placing Eleanor at the scene of any alleged poisoning act. He argued the possibility of innocent explanations for the pesticide bottle and for the financial conversations.
He reminded the jury that Eleanor was 83 years old with no criminal history. He described his client as an 83-year-old woman who had lived an entire life and whose freedom was at stake, and who deserved the jury's most rigorous and careful evaluation of the evidence. He was precise and he was thorough, and he was doing what the job required. He did not look at Eleanor while he argued. He looked at the jury, and he spoke to the jury, and he tried to give them a version of the evidence that allowed for a different interpretation than the one Ellison had presented. He tried with everything he had. He was a careful man, and he cared about the integrity of the process, and he believed in every person's right to the best defense available to them. When he sat down, he had done his job fully and without compromise. Ellison's closing was built around the toxicology report and the financial motive, and the testimony of Patricia Greer, and the specific documented question that Eleanor had asked the estate attorney about what would happen to Daniel's assets if he died.
She described a woman who had looked at her financial situation and looked at her grandson's estate and made a calculation. She described the dinner, the bottle, the chemical that had been found in both the bottle and Daniel's blood, and that could not have arrived there by any route other than deliberate introduction into his food. She described Eleanor's calls to the estate attorney. Not a call about family papers, but a call asking the precise question that mattered to a person with a specific plan. She described the argument that Patricia Greer had overheard, and the expression on Eleanor's face when Daniel had left the room. The defense has asked you to consider the absence of direct evidence, Ellison said. I want to address that directly. There is no witness who saw Eleanor Whitaker introduce paraquat into Daniel's food. That is true. But there is a toxicology report that tells you paraquat was in Daniel's blood in a quantity 3.5 times the lethal dose. There is a chemical analysis that tells you the paraquat in Daniel's blood came from the same bottle found in his kitchen. There is testimony from Daniel's own estate attorney that Eleanor called to ask what would happen to Daniel's assets if he died. There is testimony from a family member who heard Eleanor argue with Daniel about money, and who described Eleanor's expression afterward as resolved rather than hurt. She paused. This case does not require a witness to the act. It requires the evidence taken together to prove beyond a reasonable doubt that Eleanor Whitaker poisoned her grandson. The evidence does that. The science does that. The financial record does that. The question you have been asked to answer is not whether Eleanor was present when Daniel ingested the poison. She prepared the food. She was present. She picked up the toxicology report summary from her table and held it up briefly. This document does not lie. It has no motive. It has no stake in the outcome. It simply describes what was found in Daniel Whitaker's blood and what was found in the bottle in his kitchen. And it says the two are chemically identical. That is the truth of this case. Everything else is performance. She set the document down and looked at the jury. Cause of death consistent with acute paraquat ingestion. She sat down. The jury deliberated for a day and a half. They returned a verdict of guilty on the charge of first-degree murder. Eleanor Whitaker received the verdict with the same stillness she had deployed throughout the trial, but it was a different stillness now. The stillness of something that has stopped trying. She looked at the table in front of her. She did not look at Alcott. She did not look at the jury.
She looked at the table with the expression of a person who has run a long calculation and arrived at the final sum and found it to be what they feared. Alcott placed his hand briefly on her forearm and said something quietly. She did not respond. She sat with the tissue still in her hand, the tissue she had been carrying as a prop through 10 days of testimony. And she looked at the table and was still. In the gallery, Patricia Greer put her hand over her eyes. She stayed that way for a moment. Then she stood and gathered her coat and walked out of the courtroom without looking at Eleanor. She had known Eleanor Whitaker for 30 years, in the peripheral way of extended family, seen her at holiday gatherings and funerals, and the kinds of events that bring family members into the same rooms without bringing them into each other's lives. She had not known, at any of those gatherings, that she was in the same room as a person capable of what the toxicology report described. She thought about this walking to her car, and decided that the incapacity to imagine such a thing was not a failure of perception. Some things simply were not visible until the laboratory made them visible. The sentencing hearing was 3 weeks later. Daniel's closest friend, a man named Eric Paulson, who had known Daniel since college, stood at the podium and spoke about him. He described the Daniel he had known for 20 years, the person who remembered everyone's coffee order and brought the right one without being asked, who had driven 2 hours to help Eric move apartments because Eric mentioned it in passing and Daniel had simply shown up with a rented van. He described the last time he had seen Daniel, 3 weeks before his death, when they had eaten dinner together at a restaurant on Massachusetts Avenue. And Daniel had talked about a trip he was planning to Portugal and had pulled up flights on his phone to show Eric the route. He said he had not known, walking away from that dinner, that he would never have another one. He said that Daniel had texted him 2 days later to say he had booked the first leg of the flight and was researching hotels in Lisbon. He said he had sent back a recommendation for a neighborhood near the river, and Daniel had responded with 3 words that said he was already reading about it. He said that grief was not an adequate description of what he had been living with for the past 10 months. He said he had not found an adequate description and had come to this courtroom because it was the place where the truth about what happened to Daniel had been determined. And being here, in that truth, was the closest thing to an adequate response he had been able to find. He did not look at Eleanor while he spoke. He had decided before he arrived that he would not look at her, and he kept to that decision. Then Judge Nathaniel Crow, who had spent 10 days on the bench watching Eleanor Whitaker perform, and had catalogued every element of the performance with the attention of someone who has seen many performances and is never fooled by them, turned to the defendant. "Mrs. Whitaker," he said, "I am going to speak to you directly." Eleanor lifted her eyes from the table. "You have appeared in this courtroom for 10 days, presenting yourself as a fragile, grieving, confused elderly woman who could not understand what she was doing here. You have deployed every element of age and frailty as a kind of argument, as though the mere fact of being 83 years old was evidence of innocence. You spoke slowly when you did not need to speak slowly. You paused when you did not need to pause. You reached for tissues at moments calculated to produce sympathy. And you did all of this while sitting 20 feet from the family of the grandson you poisoned." His voice was level and unhurried, the voice of a man who has decided exactly what he intends to say and is going to say it completely. "I want to address each of those performances in turn." Eleanor's hands had returned to her lap. They were not trembling now. They were very still. You presented confusion as a defense. Throughout this trial, you implied, through your manner and your pauses and your soft voice, that you were an elderly woman who could not fully grasp what was happening to her. The evidence in this case, Mrs. Whitaker, does not describe a confused woman. The evidence describes a woman who called an estate attorney twice to understand the inheritance implications of her grandson's death. A woman who was sufficiently organized in her thinking to transport a specific chemical agent to a specific location and introduce it into a specific person's food in a quantity sufficient to cause death. A woman who prepared dinner and washed the dishes and made the kitchen clean before she left. Confusion does not produce that sequence. Planning does. He paused, letting the silence carry its weight. You presented grief as a defense. You wiped your eyes at moments when the testimony was most damaging to you, not most emotional, but most damaging. You constructed a performance of grief around the death of a person you killed. I want to be precise about that. You did not grieve in this courtroom. You performed grief in this courtroom. As a tactical instrument, for the benefit of a jury you hoped would confuse the performance with the reality. He looked at her steadily. The toxicology report that was presented in this courtroom does not leave room for grief as a defense. The paraquat concentration in Daniel Whitaker's blood was more than 3 times the lethal threshold. That is not a tragic accident. That is not a cooking mistake. That is a sufficient quantity of a highly toxic compound to be absolutely certain of the outcome. Eleanor was looking at the table. Her jaw had set. You presented age as a defense, the judge continued. Not explicitly. You did not argue in court that 83 years old is an excuse for murder. But the entire architecture of your presentation in this courtroom was built on the implicit suggestion that a person of your age could not have committed a calculated crime. That suggestion is an insult to every elderly person who has lived a long life with honesty and care and has never needed their age to excuse anything. He paused. Age does not excuse deception. Age does not excuse cruelty. Age is not a certificate of innocence, and this court does not treat it as one. He picked up the sentencing documents. Daniel Whitaker was 41 years old. He had inherited a home and a sum of money from his father, your son, who had spent his life building those assets and had intended them for Daniel. Daniel was not a wealthy person. He was a working person who had been given a modest inheritance and who was living his life without extraordinary drama or ambition. He was planning a trip to Portugal. He was making dinner plans with his friend. He was 41 years old. The judge's voice remained level. You decided that those assets belonged more properly to you than to him. You decided this not on any legal or moral basis, but on the basis of your own financial need and your own willingness to act on a calculation that most human beings would find impossible to make about a member of their own family. You invited him to dinner. You prepared his food. You poisoned him. And then you drove home and waited. He set the paperwork down and looked at Eleanor Whitaker for a moment without speaking. The science presented in this courtroom by Dr. Vasquez was not ambiguous.
The compound in Daniel's blood was the same compound in the bottle that was found in his kitchen. That comparison has a confidence interval of greater than 99.9%. There is no scientifically credible alternative explanation for those findings. There is no accident that produces that result. There is no confusion that produces that result. There is only deliberate introduction of a lethal agent into another person's body, which is what you did, and which the evidence in this case proves beyond any reasonable doubt. He picked up the sentencing documents again. Eleanor Whitaker, it is the sentence of this court that you be committed to the custody of the Indiana Department of Correction for the remainder of your natural life, without the possibility of parole. This sentence reflects the nature of the crime, the evidence of deliberate planning, the breach of the most fundamental trust between a family member and the person they claim to love, and the irreversible loss of a life that had every reason to continue. He paused one final time. Age does not excuse deception or cruelty. You are 83 years old, and you will live the remainder of your life in prison because of a choice you made. Not a mistake, a choice. Eleanor Whitaker was escorted from the defense table by 2 court officers, one on each side. She moved with her familiar, careful pace, each step deliberate. But the carefulness now was not performance. It was simply the carefulness of an old woman who needed to watch where she put her feet. The cardigan and the tissue and the assembled architecture of fragile grandmotherhood had been stripped down to their constituent parts by the toxicology report on the screen and the judge's words in the air. And what was left was an 83-year-old woman walking out of a courtroom in the company of court officers who were holding her arms, not out of deference to her age, but because it was their job to hold her. She passed through the side door, and it closed, and the courtroom absorbed the sound of its closing. And then was quiet. The toxicology report remained on the display screen, the laboratory letterhead, the highlighted text, the final line in plain language. Cause of death consistent with acute paraquat ingestion. It had been on the screen since Ellison asked the technician to display it, and no one had turned it off. It sat there in the quiet of the emptying room as the gallery filed out and Ellison packed her briefcase and Alcott gathered his papers and the court reporter saved her transcript. Eric Paulson was one of the last members of the gallery to leave. He stood for a moment near the door and looked at the screen. He looked at the document on the screen, and then at the empty defense table, and then at the door through which Eleanor Whitaker had been taken. He had known Daniel for 20 years, and had known Eleanor Whitaker peripherally, the way you know the family of a close friend, as a background presence at holidays and family occasions. He had sat across from her at Christmas dinner. He had carried her grocery bags from her car once, on a visit to Daniel's house when she had arrived while Eric was there. She had thanked him with what he had taken to be genuine warmth. He thought about this now, standing near the door of the Marion County courtroom, and found he could not reckon. He was not sure he was supposed to be able to. He walked out into the corridor. The case would be discussed in the community for months, in the particular way that cases involving the elderly and the unexpected always are discussed, with the unsettled feeling of a world that has shown itself capable of something people prefer to believe is impossible. Several of Eleanor's neighbors in Broad Ripple expressed disbelief publicly, describing the woman they had known as kind and grandmotherly and incapable of the crime she had been convicted of. Ortega read these accounts and thought about them the way he thought about most things in his work. What people are capable of is not always visible from the outside.
and the outside is often designed specifically to prevent that visibility. Eleanor Whitaker had spent her entire adult life building an outside that communicated warmth and softness and harmlessness. That outside had been her primary resource in the courtroom, and it had failed her when the toxicology report made it unnecessary to argue about the outside at all. The forensic science involved was cited in subsequent training materials for the state's toxicology laboratory as an example of how mass spectrometry comparison could resolve questions of chemical identity beyond reasonable doubt. The estate of Daniel Whitaker passed through probate under the terms of intestate succession to the next eligible surviving kin, which was not Eleanor, and which was administered by a court-appointed representative. The Portugal trip Daniel had been planning when he sat with Eric Paulson in a restaurant on Massachusetts Avenue was never taken. The display screen in the courtroom was turned off by a court officer 40 minutes after the sentencing concluded. The room went dark. The document had said what it needed to say, and it was now part of the permanent record of the court, available to anyone who needed it, unchanged and unchangeable.
The finding of a laboratory that had done its work without opinion or preference and had simply described what was there. Cause of death consistent with acute paraquat ingestion. 6 words. The kind of words that, once read in the right context, cannot be unread.